So in the last session we have discussed till the duty in the medical profession, in which we have discussed that how what should be the standard form of degree of care. We had a lot of debate on this also regarding that when the doctor will be liable, what are the circumstances, but we finally concluded that if the doctor is using the proper due care and attention like any other surgeon, okay, if he is using his capacity, whatever medicine he is giving, it would be similar to that another doctor will be giving, then it will not be the case of medical negligence. So that's we discussed. Now let's move forward and we will complete it today only, so that tomorrow we can practice lots of questions. Not tomorrow, tomorrow is Sunday, day after tomorrow. So now next we have the doctor duty to attend a patient. Now, for example, there is an emergency situation and the doctor, there is an accident, a very grievous and serious accident has happened, and the patient is being brought by the ambulance in the hospital. But however, but the doctor is not available there in spite of his duty. For example, the time of the duty of the doctor is from 12 p.m. to 10 p.m. Okay, from 12 p.m. to 10 p.m. is the time of the duty of the doctor. He is not available in spite of that. In that case, he will be liable if anything happens to the patient, and even if it does not happen anything to the patient, it is an implied that you should be present there, as a result of which the patient has suffered a lots of blood was lost of the patient. Now this is the case of the Sisi Rajan Saha versus State of Tripura, in which the petitioner's son Asim Saha, while coming from Agartala to Udaipur on scooter, met with an accident. Okay, he met with an accident and he was admitted to the emergency ward of the hospital. Now the senior specialist doctor was not available in the hospital. However, in spite of calling the nurse and the compounder and the staff of the hospital, they called him severally, but he was busy in taking care of his personal patient. Okay, he was taking care of his personal patient. You must have seen that the government hospital doctor, apart from their government work, they open their private clinic. So in these circumstances, what happened, that the same thing happened here also, that in spite of calling him repeatedly, the doctor did not came and check this patient who met with an accident, as a result of which the patient died. Now this doctor was asked to pay a compensation of 1,25,000 as compensation for the death of the deceased. Now something must be coming in your mind that बस 1,25,000 से क्या होगा, उसका तो जिंदगी खत्म हो गया. Guys, see, our Indian law, the law in our India is not, deterrent theory we don't have. We have reformative theory. We want the criminals, we want the accused person to get reformed. In the colonial period, we have very strict rule for, you must have, if you have read somewhere, it was eye for an eye. So if you, in the colonial period, if you tell something defamatory, now if you tell something defamatory, the maximum punishment is of 6 months and a fine of 1,000 rupees. That is maximum according to the IPC. But in the colonial period, if you see, that time what happened, just you see the content of court. Okay, you see that Prashant Bhushan, he was charged with only 1 rupees, and there also the maximum imprisonment is also very less. Even in the case of other offense also, if you just say that, like the section 354 of the IPC, that is outraging the modesty of women. So this is a very heinous crime. Okay, because in this world, men and women are equal, but the punishment is only 1 year. So you must be thinking that 1,25,000 का compensation दिलवा दिया कोर्ट ने. This is very less, but this is prescribed in our IPC. It is the judge, whoever was sitting in this case, वो अपने personally, he did not personally give this compensation, but it was according to the IPC, as it is mentioned in the IPC. So our Indian law is reformative law. We want to reform the criminal. However, in the colonial period, what happened, if you, for example, I tell something defamatory about somebody else, then what will happen, my tongue will be cut throat. Okay, my tongue will be cut. If I perform some wrong with my hand, so my hand will be cut. That was of the colonial period. Now this is in this independent country, we do not follow this kind of law. So this was the compensation that was given because it was the negligence on the part of the doctor, that in spite of being a government doctor, he was busy in seeing his private doctor. Now comes the contributory negligence. So as we have read many times, we have read that this one, voluntary non-fit injury, is one where the plaintiff himself has consented to the harm, and second we read that the plaintiff is himself the wrongdoer. We have read this. Yeah. We have read this that the plaintiff is himself the wrongdoer in some cases. Now here is the same is the contributory negligence. When the plaintiff, because of his negligence, because of his lack of care, damage is caused to him, in that case he will be considered guilty to be the contributory negligence. This is similar to that of the plaintiff, the wrongdoer. Okay, so see that that there is a case, for example, that a old woman is there is a man who is walking on the wrong side of the road. Okay, there is a man who is walking on the wrong side of the road. Listen very carefully, I will be asking question. So there is a man who is walking on the wrong side of the road. He is the plaintiff, and a car is coming from the right direction. The car is in the right direction from the opposite way, but the headlight of the car is not working. Because the headlight of the car was not working, as a result of which the plaintiff, this car driver, hit this man who was walking in the opposite direction. Now, whether in this case contributory negligence can be applied or not, yes or no, just you can type in the chat box. Whether in this case contributory negligence can be taken into consideration or not. That the plaintiff was walking in the opposite direction. Yeah, very good. So this is the case of the contributory negligence, because although it was that the headlight of that defendant was not working, it is okay, but here the plaintiff is also liable, will be contributory negligence will be there, because she was also walking in the opposite direction of the road. Okay, now see, the same thing is there. If A, going on the wrong side of the road, is hit by a vehicle coming from the opposite direction and driven rashly by B, A can be made with the defense of contributory negligence on his part. So there was the contributory negligence in this case. Now see, there is a case of Bejlam BB where the conductor of an overcrowded bus, he invited the passenger to travel on the roof of the bus. You must have seen, this will not happen in Mumbai and Delhi. This you will not see. This you will see in small villages. Okay, like Muzaffarnagar, Sivan, and all this type of villages, small town. Okay, this thing you will not see in Patna or this Mumbai, Kolkata, Chennai, but this happens generally. You will see in the small town. So the same thing was here also, that the bus was overcrowded. Now the conductor told, चलिए चलिए ऊपर चढ़ जाइए बहुत बढ़िया. They thought that किसी तरह पैसा मिल जाएगा, no issue, ऊपर चढ़ा देते हैं सबको, very good. The driver ignored the fact that there was passenger on the roof and tried to overtake a cart. Now passenger were on the roof sitting. अब उनके पास तो कुछ पकड़ने का नहीं है, वो तो वहाँ चढ़ के बैठ गए किसी तरह, है ना. दे और वहाँ पे भी ओवर क्राउडेड, एक दूसरे के ऊपर सब लटके हुए हैं. Now जैसे ही when the driver of the bus, he tried to overtake the cart and he swerved the bus to the right. The bus went on the Kacha road and the passenger sitting on the roof was hit by a branch of tree. And one of them fell down and several injuries were there to one of them. All were injured, but one of them was injured very severely and then he died. Now here the question comes that whether both of them are liable or not. Here the driver and the conductor, they were negligent. Definitely they were negligent for inviting the passenger in spite of knowing that sitting on the roof is dangerous. But there is contributory negligence on the part of the passenger who, in spite of knowing that there is risks on sitting on the roof of the bus, they went and sat on the roof of the bus. This is your what? Contributory negligence example. I hope it is clear to everyone. What is the ratio of punishment of each party in? Yeah, that is taken into consideration by the court following the IPC rule is there. Okay. So what, there is no such ratio that 50-50 or something, not like that. But what will happen, see, I am telling you, generally what happened, we reduce the punishment of the defendant. Okay, for example, take this case only. For example, now the person who has died, his wife or his father or his mother has brought a suit against the owner of the bus. As we know that master and servant relationship, I guess you guys remember master servant relationship, है ना. तो master servant relationship के according क्या होगा, the owner of the bus will also be responsible. Now a suit is brought against him. Now for example, this KA is who I want to look. Is it Kashish? KA? Okay, so whoever it is, KA. So for example, KA is the judge. Now in front of KA, the owner of the bus, he pleads that, sir, although this was my mistake, my driver mistake, that he invited the customer or the passenger to sit on the bus, but there was contributory negligence, sir. There was contributory negligence on the part of the passenger also. Now the KA will tell, yes, definitely there is contributory negligence. So if the punishment was of if the punishment was of 1 year, I'm taking, this is a hypothetical situation I'm giving you. If the punishment was of 1 year, then it will be reduced to, for example, 6 months, 7 months, in that way. No, it is not that the plaintiff will also be liable. He will also go to imprisonment or something like, that's not like that. Generally, I am telling you, generally the punishment of this defendant is reduced, mostly it is reduced only. So that is the case. Okay, now we come to the last opportunity rule. Whatever we are teaching in this lecture series, you will see the same exact question will come on these issues only. And those who have given Clat 2021, they must have even practiced in the same way, that the doctor negligence, then the plaintiff the wrongdoer, contributory negligence, last opportunity rule. One question will be, question number 1 will be on negligence. Question number 2 will be on doctor negligence in medical profession. Question number 3, doctor did not attended the patient. Question number 4, contributory negligence. Question number 5, last opportunity rule. Now 5 questions are ready. Always, as we tell, that that whoever is making the question paper, he should be having that much of question, matlab, so much detail that he can also make 5 to 6 questions. Making 5 to 6 questions is not easy. Next, we have the last opportunity rule. This is also important. So, when two persons are negligent, the one of them who had the last opportunity of avoiding the accident by taking ordinary care should be liable for the loss. Okay, we will be discussing the example, don't worry. So, even if the defendant was negligent, okay, even if the defendant was negligent on his part, but if the plaintiff on his part had that opportunity to avoid this accident, if he did not use that opportunity, then he will be liable for the losses. He cannot make the defendant liable. For example, see, the case is there, Davis versus Mann, where in this case the plaintiff fettered the forefeet of his donkey and left it on a narrow highway. Okay, what happened? Fettered matlab ki bandh ke. Okay, so the donkey forefeet was fettered by the plaintiff and he left it on the narrow highway. Now the defendant was driving his wagon driven by horses very fast, that is negligently. He ran over and killed the donkey. Okay, he ran over and killed the donkey. Now, in spite of the own negligence, that is, in spite the plaintiff had done wrong, that he fettered the forefeet of his donkey and kept it on a narrow highway. Narrow highway. See, the words are always, we tell the words are game. Okay, law is the game of word. So, in spite of the negligence on the part of the plaintiff to forfeit the donkey, to fetter the donkey on the narrow highway, but he will be he will not be responsible, or his compensation will be reduced, or his punishment will be reduced, because the defendant had the last opportunity to avoid the accident. So that, because if the defendant had not been driving so negligently, see, if the defendant had not driven his wagon very fast with his horses, that the accident would not have occurred. And in spite of seeing that there is a donkey, he did not slow down, something like that, and he ran and killed the donkey. So the defendant will be liable in this case. So the plaintiff will be entitled to claim to get this compensation. Now there is another question. You can get a question number 6, that is the contributory negligence of children. So it is very clearly mentioned that what amount to contributory negligence in case of a mature person may not be a case of the adult. Okay, for example, you take we have section 82 and 83 in the Indian Penal Code, where it is still that nothing is an offence which is done by a person below the age of 7 years of age, and 83 tells that nothing is an offence which is done by a person of the age 7 to 12, age of 7 to 12, if he does not have that much of understanding and maturity. That is the case of the children. So it is very clearly mentioned in IPC that nothing is an offence which is done by a children 7 years of age below, or up to 12 years of age, if that person does not understand what he is doing, the consequences, he does not have enough maturity. Okay, so let's see contributory negligence. So these children will not be responsible. There is a case of R. Srinivasa versus KM, that is a child of about 6 years was hit by a lorry while standing just near the footpath. It was held that a child of that age does not have the road sense or experience of his or her elder, and therefore there is no contributory negligence. He was standing there, he does not understand. A child of 6 years. Okay, that only I am telling. No, if this would happen in the colonial period, then the child would have libel. But our is a very different law, guys. Okay, so here the law assume that this child will does not have, because directly it is mentioned in IPC under section 82 that a child of 7 years of age is nothing is an offense by them. So the law will assume that because he is standing, he does not have enough of maturity at that time, he does not understand that अगर मैं यहाँ पे खड़ा रहूंगा ऐसे, तो हमें जब हम 3 4 4 साल के रहते हैं, वी गो ऑन वॉक विद आवर पेरेंट्स, उसी समय से हमें टाना जाता है, बोला जाता है राइट साइड में ये नहीं चलो, लेफ्ट साइड में नहीं चलो, यहाँ फुटपाथ पे चलना है, ऐसे करना है, वैसे करना है, वट एवर इट इज, the law will assume that he does not have that much of understanding. He will understand that whether I should be standing near the footpath and or not, and that all thing. So that is the thing, that in case of contributory negligence of the child, he will not be liable. Now we come to the very important issue, that is the strict liability and absolute liability. This is a very important issue. See, one is the voluntary non-fit injuria, second is defamation, third is negligence, and fourth is strict liability and absolute liability. These are the most four important issue of your tort whenever any question or come in Clat or in your mock. These are the four most common passages that you will be getting. So strict liability and absolute liability. This is a very important issue. First is the strict liability, then we will be discussing the absolute liability. So strict liability was a concept which came in the case of Reynolds versus Fletcher. Okay, according to strict liability, if a person keeps any hazardous substance on his premises, he will be responsible if such substance escape and cause damage. So guys, this is very important, understand very nicely. See, this is very important, strict liability and absolute liability. If any person keeps any hazardous substance, so first is that the substance that you have kept on your premises, whether in the industry or whether in your ground or whether in your house also, it should be a hazardous substance. Now he will be responsible if the substance escape. Now if you are keeping, you are not responsible. This is not your drugs. Okay, कि 10 किलो गांजा घर में रखोगे, 10 किलो तो बहुत ज्यादा हो गया, 50 ग्राम गांजा अपने घर में रखोगे तो पुलिस आके उठा के ले जाएगा, रेड मार देगा, ठीक है, 10 किलो तो नो वन विल गिव यू ऑल्सो इजिली. So 50 gram ganja you will be keeping and police will come and raid in your house. That is not the case. If the hazardous substance escape from your premises and cause damage to anyone, then only you will be liable for strict liability. I am giving you the best example of this. For example, tomorrow Pankaj grows a very uh, poisonous tree in his premises. He has become a very successful lawyer. Congratulations, Pankaj. Now he has grown lots of poisonous tree around his house. I don't know why. Don't ask me why. Okay, अब उगा दिया तो मैं क्या कर सकता हूँ, मैं थोड़े काटने जाऊंगा उसे. So he has grown it very good. It is there looking very beautiful. Although it is poisonous, but it is looking very beautiful. Everyone is seeing it. Very good, Pankaj. Now one day what happened? The let me check someone name. Then it will be more interesting for you all. Now yeah, Subham ji. Now there is Subham has a take for example, Subham has a horse. Okay, Subham has a horse. No, Subham horse is very matured, बहुत matured horse है. He is not like that child who is standing near the footpath. He went roaming, and and he entered into the premises of Pankaj and ate that poisonous leaves of that tree, and he died. Guys, in this case, Pankaj will not be liable because there was no escape of the hazardous substance from his premise. Although there was damage caused to the horse because of this poisonous substance, but there was no escape. This is a very important term. Why I give example of this only. There should be an escape of that particular substance which is hazardous. It should escape. So this is the strict liability principle, that the defendant, only if a dangerous substance escape from his premises. Okay, now dangerous substance is anything which is like explosive thing or something like toxic gases, even electricity, the electricity that you are with which you are fencing your ground. If something because of your electricity which you have fenced your ground, for example tomorrow, और कौन है भाई, Yeah, tomorrow Ankit become an IAS officer. Okay, tomorrow Ankit become an IAS officer of Gurgaon. I know he lives in Gurgaon. That's why I'm telling him. So tomorrow Ankit becomes an IAS officer of Gurgaon. Very good. Congratulations, sir. Now what he told that my safety precaution. Let me fence my whole ground. Okay, my whole premises with electrics. Because of the escape of his electric, there is fire in his surrounding. Okay, in the neighbor. So although he is a public servant, okay, but if you take it in other way, then he will be liable. Don't consider that with the noise prevents. Keep that aside. That public servant he is. That is another thing. But electricity has escaped. It is a dangerous substance and it has caused damage. So very important is that that substance should escape from the premises and shouldn't be with the reach of the defendant after its escape. This is very important term. Now, so to constitute the strict liability issue, there should be the non-natural use of land. Now, so there is example given that the supply of the cooking gas through pipeline, electric wiring in a house, these are the natural use of land. Okay, so for instance, if the defendant light up a fire in his fireplace and a spark escape and causes a fire, then the defendant will not be liable. This is very simple. For example, now that electricity is too much electrocution you have done. See, understand these two things. For example, your house and your neighbor house, Priyamada and Sony house, is they are close, very close. Okay, there is no, they did not follow the municipality rule. Municipality rule बोलता है ना बीच में गली छोड़ना पड़ेगा. They did not follow the municipality rule. Very good, no problem. नहीं छोड़े हल क्योंकि लॉयर है क्या दिक्कत है हमारे ऊपर कौन केस करेगा. Okay, so now what happened because of this lighting up of the fire in his fireplace, the some electricity from there or something happened and it went to Sony house, okay, or KA house, because of which there was fire in the house of KA or Sony. In this case, Priyamvada will not be liable. Okay, because it is the natural use. No one, it is not every time, it is not this is reasonable. ओके दैट इलेक्ट्रिसिटी नहीं रहेगा घर में तो आदमी काम कैसे करेगा उसके कारण चल गया दैट इज नेचुरल बट प्रियमदा टुमारो बिकम द फर्स्ट आईपीएस ऑफ हर विलेज नॉट द फर्स्ट आईपीएस ऑफ इंडिया दैट इज द रेस्पेक्टेड किरण मैम ओके so first woman IPS of her first woman IPS of her village Priyamvada become very good congratulations. Now she told that I have very बहुत खतरा है मेरे को सर मेरे को बहुत खतरा है मैं पूरा इलेक्ट्रिक्यूशन करा दूंगी चारों तरफ से आपको भी अंदर नहीं आने दूंगी. Okay, no problem. I will not come. Now, so what happened that she has done all the kind of electrocution, and now because of this electrocution, the spark went and मैं बगल में ही रहता हूँ. मैंने कहा चलो ठीक है प्रियंवदा मैं एक छोटा मोटा लॉयर हूँ. मैं भी तुम्हारे घर के बगल में बना लेता हूँ घर. You will give me some promotion also, I guess. Some work you will be giving, whatever law purpose, law function you will be having, give it to me. So I made a house of mine in बगल में प्रियंवदा के बगल में, and because of the electrocution purpose, the fire spread and my whole house is burnt. Don't do this, Priyamvada. Okay, so now in that case, Priyamvada will be liable. Okay, so okay, that is the rule of strict liability. Now there is some difference between. So there is yeah. Now there is a difference between strict liability and absolute liability, and here come the difference, guys. Okay, that is the thing why we are doing this law lecture series ताकि everything is given in the paragraph, but just reading the paragraph at once in the mock or in the Clat paper and solving all the 5 questions is not possible for everyone. So if we know from before that what is absolute liability, what is strict liability, what is the difference, it will be easier. We will just give a speed reading there and directly we will be solving the question. Now this is the difference between guys strict liability and absolute liability. That in strict liability you have the exception, in absolute liability you don't have the exception. अब सर इसको याद कैसे रखेंगे कि कौन सा क्या है? Simple है. The absolute means what? Complete, no exception is there in absolute. Strict में exception is there. Okay, so very good. So this is the exception to the rule of strict liability. Let's see. The first is the plaintiff fault. That is the plaintiff the wrongdoer. That is the general defense is taught that if the plaintiff is at fault and any damage is caused, the defendant won't be held liable as the plaintiff himself came in contact with the dangerous thing. Same example I am giving you again, the horse one. Pankaj and Subham horse example. Here Pankaj will not be responsible because it will be the responsible of whom? Shubham, because his horse came into my premises and he ate. My substance did not exit. My hazardous substance did not escape from my premises. So how I will be liable? So this is the case of Ponting versus Nokas. That is, a plaintiff horse died after it entered the property of the defendant and ate some poisonous leaves. Okay. So this happens when you study lots of tort. Before the thing come, you give the same example. Okay, guys. So let's move forward. Next is the act of God. Second exception is act of God. We have also already discussed this, that something which is beyond the control of any human agency, which is a natural thing, something which is natural like the earthquake. We have discussed the Bocute Hall case. Okay, that there is a party given by Subham. Subham did not invited me and Kanish Bhaiya. No problem. We will come in spite of that. But Bacute Hall was only broken because of the thunderstorm, barish. There was lot of rain, lot of thunderstorm, and then finally there was an earthquake of magnitude. I don't remember the magnitude that I told. It was 2.2 or 3.2, whatever it is. Shubham, no problem. But you could not celebrate your birthday because you did not invited me and Kanishpia. So that is an act of God. In this case, now in this case, what happened? What I'm telling. For example, there is a hazardous substance kept in your industry. Okay, jokes apart, there is a hazardous substance kept in your industry, and because there was a flood, your industry is in the ground floor. There was a heavy rain. You must have seen now in Mumbai, Chennai, Bihar, everywhere there is flood only nowadays. So let's take the example of flood. There is an industry. Okay, so who is left? They will tell that भैया मेरा example नहीं देते. I hope I've given the example of everyone. Okay, so let's give the example of Kanish Bhaiya. So Kanish Bhaiya has become a very big judge of Uttar Pradesh High Court. Okay, now because now he has just completed his LLB, so he has become a judge of Uttar Pradesh High Court. And don't worry, he will be the judge of Supreme Court also soon. Okay, so congratulations to Kanish Bhaiya. Now what happened? Kanish Bhaiya बोला कि अरे ठीक है बहुत पैसा है, टैक्स तो भरने का टेंशन नहीं है. Okay, don't do that Kanish. उसने कहा कि चलो मैं इंडस्ट्री खोल देता हूँ 4-5 पूरे जोनपुर में. माई जोनपुर पीपल सफर्ड अ लॉट व्हेन आई वाज स्टडीइंग, सो लेट मी ओपन लॉट ऑफ इंडस्ट्री इन जोनपुर. ही ओपन लॉट ऑफ इंडस्ट्री इन जोनपुर. नाउ देयर इज द फ्लड इन जोनपुर ऑल्सो. ओके, फ्लड कहीं भी आ सकता है, कोई पहाड़ी इलाका हो तो अलग बात है. तो फ्लड इज देयर इन जोनपुर एज अ रिजल्ट ऑफ विच ऑल द हैजार्डस पॉइजनस एंड ऑल दैट गैस सोडियम एथिलीन फिथिलीन एंड ऑल. I am although a science student, but I don't remember chemistry. So whatever are the poisonous gases, all they were on the road, as a result of which people started dying. Very bad, Ganesh. This is, I will, even if you have act of God, then also I will make you liable. You come to my court. So the people start dying. Same as the Bhopal gas tragedy. You must know that still today people are suffering because of the Bhopal gas tragedy. The children that were born after that tragedy, even 10 years after that tragedy, they had suffered because of that tragedy. So because of this, there was lot of people died. At least 200 people died. A lot of them were injured. Everything worst happened. In this case, Kanish Bhaiya will take the plea of act of God that sir, there was non-hazardous substance in my land. It escaped. Very bad. It happened. It escaped. It caused damage. All the three ingredients happened. But under strict liability, I have an exception of act of God that the substance escaped because of natural forces. That is act of God. That is act of God. Next, we have the act of third party. That is, the third party means the person who is not the servant of the defendant, nor the defendant has any contract with them or any control of work. So because of the act of the third party, if anything happens, if any non-hazardous substance get leaked, in that case the defendant will not be responsible because the defendant had taken all the due care. Okay, but the third party here is not the servant of the defendant. For example, Pankaj has a big industry of sodium sulfide. Okay, I got a good name from chemistry suddenly. So sodium sulfide is there, for example, although it is not much poisonous. So sodium sulfide industry is there, but hypothetical take bhai log. Okay, that if it leak, then At least minimum, the minimum people that will die around the whole surrounding of that industry is 1000. Very bad, Pankaj. No, but if that work is because of the act of the servant guys, for example, Pankaj is the owner. अब पंकज दिल्ली जाके इंडस्ट्री में तो नहीं बैठेगा, कभी कभी महीना में एक बार चल जाएगा. He is a big successful lawyer. Okay, so now he don't have time. So many client is there. Okay, outside his chamber. So महीना में एक बार जाता है. There is servant, means the staff of the industry. They are working day and night hard there. If any of the because of the act of the servant, if the work is there, if there is an uh, escape of the hazardous substance, guys, that is the master servant relationship. He will be responsible. But if because of any third party apart from this servant of the defendant or anyone who is not under the control of the defendant, we have done no servant, independent contractor. Okay, very good, we have done. So in that case, Pankaj will not be responsible. This is the act of the third party. So these are the exceptions under the strict liability. Now we come to the last issue, that is the absolute liability. Absolute liability means strict liability minus exception. So what you will get in Clat, in your mock paper, the passage that nowadays we don't consider strict liability anymore. They write in the mock. I am giving you the best example. Those who have given Clat 2021, they will agree with me also. So nowadays we don't follow strict liability. Nowadays only absolute liability is follow. But in the out of the 5 question, at least 3 question will be there for strict liability. जब follow ही नहीं होता तो क्यों question दिए उसमें सर? क्या प्रिय बताएं, right? Yeah. Okay, tax evasion कर दो. Okay, so this is the passage that gives now the absolute liability, strict liability minus exception. This was the case of MC Mehta versus Union of India, guys. MC Mehta versus Union of India is the case. Anyone? I am giving you the time till I complete. MC Mehta versus Union of India is which case? Anyone can tell me? Google भी कर सकते हो इधर में. So according to this rule, that if any person is engaged in any hazardous activity and if the harm is caused to any person due to that accident because of the inherently hazardous activity that he or she is carrying out, at that time he will be absolutely liable. Now same thing is there, more or less the principle is same, guys. Now what is the difference you will be getting in the question I am telling today only. Okay, this question must have come in the mind of most of you, especially I know PM बता के दिमाग में आ ही गया होगा अभी तक. I am telling you myself only. When you will be getting the question of strict liability, there will be a fact of exception. But when you will be getting the absolute liability question, there will be no fact of exception. Fact, you understand? No, there is principle and fact. In that manner, I am telling you that when you will be getting the strict liability, there will be some exception, something like that. In that, you will apply strict liability. When there is no fact of exception, in that you will apply absolute liability. Is it clear to everyone? Everyone? पंकज, प्रियमदा, शुभम. पंकज क्लास में है कि नहीं पता नहीं. अंकित नहीं क्लियर है. पंकज, इट इज नॉट क्लियर. ओके ओके ओके, वेरी गुड. चलिए, सो फॉर एग्जाम्पल, अगेन टेक द एग्जाम्पल ऑफ समवन ओनली फ्रॉम हियर ओनली. For example, there is a big industry in let's take the example of Delhi. Yeah, Delhi only. So there is a big industry in Delhi. Now there is hazardous work. The owner of the industry is KA. Okay, there is the owner is KA, and under him or her, I don't know. So under him or her, the work is going on. Now because of the act, because any other person came into the night and he did perform something, that as a result of which next day the steamer or the gas chamber burst, as a result of which the whole city of Delhi was under the effect of this whatever gas you consider. I am very weak in chemistry, science, not chemistry, in science only. So because of that, the whole there was the effect of that gas was on whole Delhi. Even the take the latest example, Central Vista project was stopped. Okay, vaccination was stopped. 2 करोड़ वैक्सीनेशन कंप्लीट नहीं हो पाया जिस कारण से In that case, KA will not be responsible. You will choose the option. This will be the case of strict liability. However, KA will not be responsible because of the act of the third party. This is the first thing, Pankaj. Second, you have Ankit. Mr. Ankit is the owner of the industry working in under whom lots of servants are working in Gurgaon. Okay, so very good. So Gurgaon में अंकित का industry है. Now there is the dangerous substance is there, and the substance, because of the act of the servant of Ankit who is working there. So all this now happened with computer. Now no more we are working with hand. If you have seen the working of the industry, that there also they have a computer room where everything is done with the help of computer. Even the passing of the gas, mixing of the gas, opening the gas chamber, closing the gas chamber, this all depend on the computer and laptop. This work are done in the laptop and computer. So the servant, one of the servant of Ankit, he did not close the gas chamber in night. Okay, every day the gas chamber has to be closed in night. Otherwise, and should be open at 4 a.m. in the morning. Otherwise, that gas chamber will burst. Okay, very good. At 4 a.m., Ankit's servant was sleeping very coolly. Okay, and very bad, Ankit. Now you are going to get into trouble. Although you are a lawyer, you will defend your case. So at 4 a.m. it was not open. The gas chamber was not open, as a result of which it bursted, and a very poisonous gas XYZ. Okay, XYZ, it bursted and it had affected the whole of Gurgaon. This is the case of, sir, absolute liability. Nowhere mention of third party, act of God, or the plaintiff is himself liable. Because of the act of the plaintiff, something wrong has been done. This is the whole understanding of the tort under your legal lecture series, that what is, we started with what is tort. These two maxima are also very important. Generally you get question on this in mock, not in Clat paper. In the mock you must be getting diamond, cyana, injuria, and injuria, cyana, diamond. Then we discuss, this is very important, all these are combined together and given in one passage, that is the types of the general defenses in tort. We discuss each of them in detail with the example, and then we came to the statutory authority. Then we come to the vicarious liability, that is the master, servant, principal, agent we discuss. And then we came to the doctor case. We discussed the false imprisonment, very important issue of for Clat and even for your mock, that is defamation. This is a very important issue. Okay, you will be getting question day after tomorrow, don't worry. What are the defenses in defamation? Then we discuss the negligence, the duty of the care the doctor should be performing. And today we discuss a very important issue, that is the strict liability and absolute liability. Last opportunity rule you should remember. And strict liability, Reland versus Stretcher, and MC Mehta versus Union of India case, that is your absolute liability. This is your whole concept of tort. Nothing is left. All we have discussed, the only thing is done is to practice lots of questions. So we stop here only today. We will discuss the question in the next session.